here. And as the recording in progress just noted, we are recording this matter just to kind of make sure that if anybody wants to see it again, they can. So here's what we're going to talk about today. We're doing an open meetings discussion, and I would really love to hear your questions because frankly, the law is out there. Most people know it. If you're on this call, you've probably had to deal with it before. And I definitely don't need to tell a group of folks like you that what's going on with the open meetings law. What I would love to do is get some prompts from you and some thoughts, and kind of give you my thoughts as you have those prompts. But to the extent that doesn't happen, that's okay too. I know that not everybody is as amped up about the open meetings law as I am, right? It's certainly something that I do every day. But look, at its heart, the open meetings law is about due process, right? Due process is just so important to what we do. The open meetings law. Hang on, I'm going to go ahead and share my screen here. I do see a few folks who were here last time, so if you've developed more questions since the last time you were here, please don't hesitate to say something to the effect of like, hey, I asked this last time, and I've since then I found something else, and Scott, I want to talk to you about it. So hang on, lowering this screen over here, and then I'm going to put the PowerPoint over there, and we're going to get rocking and rolling. But just quick question: does anybody have any opening questions before we get rocking and rolling? Okay. All right. So this is the presentation. I am all right. Y'all can see my screen, right? Everybody can see it? Great. So look, the open meetings law is really self-explanatory, folks, and it starts right there at 4211. And it is a chapter that is quite short considering the actual breadth and scope of it.
Scott, can I interrupt you for a second? Can you make your screen a little bit larger? It's hard to read.
Which one are y'all seeing? Are you seeing one with like a ticker and it's got a clock on it and it says next slide?
Yes, I think that's what I'm looking at.
This is why I hate
there we go. That's it. There you go. Got it.
Much better.
Zoom is awful. Hang on one second. I'm going to fix this problem right now. Like I said, anybody got any questions that I can answer while I'm doing this little fix right here? No. Bueller. Anybody got any recent open meetings law problems that they've come across? No? All right. Okay. I got this going for you here. Share screen, share Acrobat Pro, share. All right. How's that? Is that better, Garland?
Perfect.
Perfect. Great. Okay. So here's where we were. We were on the open meetings law itself. Let me see. A little bigger. Like I said, it is a law that is quite self-explanatory, and it's all right there. There's not a ton of open meetings jurisprudence. Does anybody know why that is? I'll tell you, the reason there's not a ton of cases about the open meetings law is because, frankly, it's hard to justify the cost. And as an added bonus, the DAs and the folks who are charged with enforcing the law, they don't like having to sue or do criminal charges against somebody that they've that maybe they were elected with, or maybe they served on a council with, or in the legislature or something of that nature. And so they generally don't enforce it. I've only seen one instance of the Attorney General enforcing the open meetings law. And that was because, it's going to be shocking to everybody here, but the Attorney General had a political issue that he wanted fixed, and couldn't have anyone else handle it. So instead, he just went ahead and put it up on and then prosecuted an open meetings offense here in Jefferson Parish, actually, where I live. So that was a one-time thing, though. I doubt that we're going to see any magical enforcement of the open meetings law anytime soon. Like I said, enforced by the actual law enforcement in your parish, Carissa put in the chat that there was a mayor trying to overturn a vote that was against an item, and he said he was enacting his veto. That really, I did get that question, and we talked about it, but that's really not an open meetings law question. That's really a executive power question with some executive power with a little what does the local charter say sprinkled on top. No offense, but I don't think that really qualified, but I was happy to answer it, obviously. So we got that. I've seen a few other ones recently, particularly related to COVID. Folks they're used to meeting, by Zoom, and they like the concept of meeting by Zoom, we've got that as well. I just want to remind everybody what a meeting is, right? So, a meeting is a quorum of a public body that gets together to deliberate or act on a matter over which the public body has supervision, control, jurisdiction, or advisory power. And, what does that mean? Well, it means that if they're all getting together, to talk shop, at somebody's house, and there's a quorum of them there, which is 50 plus 1, that is a meeting. If 10 members of a 15-member board all happen to be at the same campaign party for the parish president, that's probably not a meeting, right? It's not, at least it's not supposed to be a meeting. How about that? And in reality, we've just never, as an industry, prosecuted those cases because they're, number one, hard prosecuted. Number two, the resolution or the result of a successful open meetings prosecution is that they just rehold the meeting. So, there's really not much that results from it, other than some good stories and holding them accountable. There's not a lot of teeth to the open meetings law, unfortunately. But that said, it is a good law, and we have one of the better laws, in the nation. So I'm sorry, was there a question? No.
Scott, this is Harlan in Annapolis and Eunice.
Hey.
And wanted to point out, you were to an earlier comment that you made about the expense of going to court on these people, or going to the DA, who's going to be reluctant, used to work paper owned by NYT. And their lawyer, of course, back then they had deep pockets, but their lawyer said your best bet was to relations, open meeting of records. Your best defense on that was to just write stories about it.
Absolutely.
We got more ink and paper than they do.
That's a great point, Harlan. And look, when people break the law, if we don't cover it, no one will ever know but us. And the reality of that situation is that, if we don't alert the public, our readers, even the folks who don't subscribe, that their government is breaking one of the fundamental tenets of the law, then we get what we deserve. Frankly, the reality is that we have to hold them accountable when they're breaking that law. And I'm gonna pick on Garland because he calls me every 5 minutes. But if we don't do that, then we will, kind of, I guess, for lack of a better word, we get what we deserve. I mean, we've got to start, being aggressive in covering these types of situations. So every meeting has to be open. All votes have to be via vace, which is a really fancy way of saying that they've got to do it by voice. But I know that you all already know this. You can't have a secret ballot, things of that nature. But I want to talk about executive session, because that's the biggest questions that I get, or at least about executive session. They can only go into executive session if they have an affirmative vote that says, we're going into executive session. This is why we're going into executive session. There are only, there's an enumerated list of reasons, and then you got to have a 2/3 vote. And on top of that, you cannot vote in executive session. Now, this is often confused by reporters. It's often confused by the lawyers that advise these folks that, oh, well, you can vote in an executive session. That's not correct. You can talk in executive session and come out of executive session and make a decision, but you can't come out of executive session and say, we ratify everything we did in executive session. Can't do that. What you can do is come out and say, we would like to instruct our attorney to proceed with the legal strategy outlined in the previous executive session, right? Because that's usually the best, in my experience, that's the best kind of executive session example that really kind of makes sense, is the attorney-client privilege. And let me explain why. Just like if I were to represent any of you in a defamation case, right? The attorney-client privilege, these governments all have lawyers. Now, are those lawyers any good? That really doesn't matter. But most of us know that they don't necessarily know this law as well as we do. But because those folks have lawyers, they're allowed to exercise the attorney-client privilege just like you are. And if we had to have an open meeting where you could hear the advice that the attorney was giving to that to that body that is required to have public meetings, then the opposing lawyer could just show up and hear what their plans are, or how much money they want to offer to settle. But because usually when you're settling the case, Garland will tell me, Scott, we'll settle this libel case for $5,000, but see if you can get 3,000 first. Let's see if we can get them out for 3,000, right? But well, if somebody could just show up and listen to Garland's instructions, they're just going to say, well, no, I want all 5,000 that they told you could have. So there are reasons for executive session, but usually what they're doing is they're talking to their attorneys, or they're discussing the character and competence of an employee. And yes, that does include people who are on the board, people who are on that committee or commission. The character and competence of that person is also set in executive session. Investigative proceedings and security proceedings are also things that we've been seeing a lot. Anything having to do with students, your school boards will go into executive session, because they're really not supposed to be talking about minors in public. And again, that makes sense too, as when you're dealing with a minor or an employee. But remember that if it's an employee or a person who's on the board, they can demand that the hearing be held in public, and they have to have 24 hours notice that they're going to be discussed at this meeting. So if you're covering a meeting and a principal at a local high school is about to get fired, a question that you might consider asking is, did you get notice from the school board that they were going to talk to you? Did they tell you that you can demand this be in an open session and not in executive session? And most of the time they don't get notice, and they are not informed of the law, which is that they can demand that it be an open session. And that always produces some very fun stories. So I highly recommend taking a look at that, folks. Let's see. School boards do have special provisions in that, they have to allow public comment prior to each and every vote, which makes school board meetings very long. Of course, the Orleans Parish School Board is different, because why do everything the same here in New Orleans? We're very special. But at least we have running water, unlike Jackson.
So Scott, let me go back and ask them, can a school board limit the discussion of a person to 3 minutes, or tell them they can't talk because they were not placed on the agenda?
That's two questions.
Yeah.
First question, yes, they can impose reasonable limits. Otherwise, meetings would take days, not hours. 3 minutes is a little low, but reasonable limitations are okay. No, you can't tell somebody that they can't talk because they weren't on the agenda.
Scott, before you get into the COVID stuff, is a group text amongst board members, that's not considered a illegal meeting? If they start talking about, I don't know, I mean, how they go vote on something, or, polling each other and feeling each other out and sharing information.
Yes. Yeah, that's an illegal meeting.
I drank coffee with one of my school board members, and that son bitch gets texts all afternoon from it's the whole board text.
Look, we know about the texting. If there was an easy solution, or somebody was willing to put up the money, I'd love to have that fight.
But I don't think they even know that. They don't think they're doing anything wrong. I think maybe look at putting something in the law. Maybe, I don't know how much trouble that would be, but because I don't think the law addresses electronics, right?
It does, not in that way. It doesn't address text messaging.
Yeah, they do it all day long.
Well, of course they do, and we know that. I know that at least. And David, David, the problem there is custody and control.
Yeah.
Who has custody of that phone? It's probably not the school board.
School board they give them all laptops. I don't know if that's hooked into their iCloud account, but
I don't know. It's different parish, but
they do it all day long.
I can tell you this: If it's a school board issued cell phone, you got them dead to rights.
Yeah.
If it's a personal cell phone, there is not an easy answer. And that's a case I'd love to litigate. But, you know,
Right.
like I said, if anybody got $50,000 for me to figure that out, I'd enjoy that. Yeah, no, but I mean, it's a real problem, David, and we know it's a problem. As y'all know, during COVID, you know, we went to these online meetings. One of the first things that we did, you know, March 16th, 2020, you can see one of the first things we did was we sent a letter to the municipal association, police juries, and school boards and said, hey, look, we know that you're going to have to meet online. All we want is notice. Okay. And we want the ability to cover the meeting. And that was a decision that we made as that the LPA made as a board. And, you know, fortunately, by being on the forefront, we actually set the standard for most of the country and how they responded during COVID. And accordingly, in 2020, the legislature passed a law that's it's 4217.1, and it says that in a state of emergency, and look, guys, it's hurricane season, so we're about to, you know, hopefully not, but there's a chance that we'll be in a state of emergency again. They can have meetings online during a declared state of emergency. So long as they certify on the meeting notice what the meeting's about, and it's, you know, in response to the emergency, that if it's delayed, it'll cause some great hardship to the public body. They're crucial to the continuation of the public body and time sensitive and critical. And they can't talk about anything else. So like they can't use the emergency provision to you know, come up with a new budget that pays everybody an extra 20 grand a piece, right? That's not germane to the emergency. And that law is something that we worked on with at the LPA. We spent a lot of time working with Senator Hewitt and Representative Stefanski about that. So yeah, the new COVID emergency law is probably going to get its first real non-COVID related test this fall. At some point, we'll have some kind of tropical storm warning or, you know, something like that, and the governor will declare a state of emergency, and then they'll have an electronic meeting, and somebody will, you know, get some raise, or somebody's, you know, uncle will get some amazing job, and we'll have a good test of the new law and its limits. Any questions about that? All right, you know, 2022 was a very active legislative session, as you all know. Fortunately, we were able to defeat a couple of different bills. There were a few that we were not able to defeat, and a few that we kind of let slip through the cracks because we were fighting bigger fights, frankly. You know, the Bond Commission law on open meetings is becoming harder and harder to advocate against. Let me explain this. The Bond Commission has a law that we worked with them on in 2020 that allowed the bond 2020 that allows the Bond Commission to have online meetings once every other quarter, no more than 3 times a year. And the reason is at the Bond Commission, you know, you've got folks from, say, Minden. Okay, you got somebody from Minden who is driving to the Bond Commission in Baton Rouge to advocate for a certain bond to be issued so that they can build a new basketball court at the high school, right? And that is a lot of time. And usually that person who's driving from Minden is a lawyer, and they're charging $300-400 an hour for their drive time, and it's costing the city of Minden all this money. Well, couple of years ago, they changed the law to allow that attorney to call in by phone and testify. Now they've decided that they want to allow that attorney to show up by Zoom. And, the way I look at it with the bond commission and some of these other boards that have gotten the same exemption, it's like the dental board and the, some committees of the Law Institute, certainly nothing of significance. Is that, those members, it's hard enough to find people to serve on those boards from all over the state. It really is hard. And getting them all to Baton Rouge for a meeting is becoming harder and harder according to the state. And, for the city of Minden, in my previous example, that's, let's say 10 hours at, let's just say $300 an hour, right? I mean, that's $3,000 that could be saved by using this form of communication that you and I are on right now. And so, I just, logically, it's hard to argue against allowing these folks to do that. Now we are kind of fighting it as best we can. One of the laws that did pass this year is a study commission to implement statewide electronic meeting laws. Jerry Rahal, our own Jerry Rahal, is going to be on that board. I will also be attending every one of them because I want to make some points and statements. So, Jerry's going to be the good cop and I'm going to be the bad cop. And, I think that what we'll get out of that is a uniform law on having online meetings when necessary. And some of the things that, I'd like to make sure is in that law is, number one, it's got to be only, in certain necessary matters. Number two, there has to be an anchor physical location so that people who want to go to the meeting can actually go to the meeting and watch it, even if they're just watching it on a screen at the anchor location. And number three, to differentiate between these two concepts of participation and observation. Okay, those are two different things. Allowing government officials and those who serve on government boards to participate in a meeting is very different than allowing a mom or dad or to watch or observe the school board meeting from their home while they're cooking dinner. Because, before you would have to go to the school board meeting to find out what they're going to do about the new middle school or what have you. Well, we've developed all this new technology. I know in Jefferson Parish, they broadcast the school board meetings on YouTube. And so my wife and I watch them because she works for the school board. And so what's going on at the school board really matters to us. And, but if every school board member, we're at, oh, excuse me, guys. If every school board member, we're at on a Zoom like this, when they didn't want you to see what they were doing, or when they wanted to take a bathroom break, and maybe they didn't want everybody to know that they were leaving. Do you know what they would do? This. Hey guys, how's it going? This is how it would be. One of the things that we always hear is that the Pardon and Parole Board wants to be able to meet by Zoom. And I am totally against that. And my reasoning for being totally against that is because the Pardon and Parole Board serves a very important function, deciding whether or not people should be able to get out of jail early or be pardoned. And a lot of times at those Pardon and Parole Board meetings, you hear some harrowing, terrible stories from the families of people who've been victimized. And if that pardon and parole board member from Minden, just I'm picking on Minden, don't know why, doesn't want to face the crying widow of somebody, all he's going to do is this. Right. And it's a lot harder to not feel the emotional impact when you're in the room. That's the extent of my PowerPoint. And this was supposed to be a 20-minute convo. I know it's longer than that because I could talk about this stuff for hours. So, if y'all have questions, please shoot them at me.
Well, Scott, what you was just talking about, the law only applies to the bond commission.
It applies to the bond commission, the committees of the State Law Institute, the Board of Medical Examiners.
Okay.
Yeah.
Okay.
Right now,
Yeah.
but it's gonna apply to everybody, y'all. I mean, this is just an eventuality. I mean, they're gonna have good reasons for some of these folks to not have to meet in person. And like I said, like with the pardon and parole board, like there are some lines that we just got to make sure they don't cross. And for me personally, that's one of them. Other questions?
Of course, I can ask a million of them. So another one, you said somewhere earlier, like it was in the Zoom meeting, they had to stick to the agenda. What happens if they put a miscellaneous item at the end of the agenda? That kind of opens the door for everybody, everything.
They can't do that.
Okay.
They can't just have like a general anything else we want to talk about.
Yeah, I've seen bodies put miscellaneous business at the end.
I mean, as long as they're not, as long as the miscellaneous business isn't a pay raise for the, board's, favored son, they might have a miscellaneous business section that, kind of talks about like, for example, it could be, complaints from the public. It could be a lot of things. The miscellaneous section portion, it doesn't bother me as long as they're actually doing what they're supposed to do,
Okay.
which is listen to the people. But look, be wary of those miscellaneous sections, Garland, because that's usually where the the craziness tends to kick in.
Yep.
Any other questions?
One more for the road. It's something you and I have discussed for 2 years now. When does an emergency end?
I don't know. I don't think anyone knows. I mean, it ends when the governor's order ends, right? But if it's a non-gubernatorially declared emergency, then it ends whenever the board or the governing association that you're talking about says it ends. And I mean, at some point, all of us are placing our faith in the government to do the right thing. Now, I think we know that that's not really a good idea, but that is the reality of what we have to deal with, which is that, it's like with public records. People always ask me, well, how do I know that this is all the records that they have? You don't. You just don't. I mean, you're kind of, like I said, trusting them to not lie. And I don't like that answer for that position, but that's kind of the way it's always been, and I don't have a better solution, unfortunately. So that's kind of where I am on that. Sorry, Garland. I wish I could come up with a better answer. It's been 2 years, I know, but I don't have a better answer. If I did,
Trust me, nobody knows.
yeah, no, nobody knows the answer. That's right. I could tell you this, my entire life is an emergency, having 4 kids under 8. So I can't imagine, what the definition of an emergency is to a public body. So, I know that they all have kind of internal guidelines for what constitutes an emergency. We'll see what actually they abide by, especially with these new laws that are coming out. Any other questions from the peanut gallery?
One more.
Yeah.
I'm looking at one of my school board agendas, and nowhere on here does it say give anywhere for public comment. Should I maybe approach them, and shouldn't they tell the public maybe in the beginning of the meeting that they have the right to speak to on some of these things? Some of I think my parish council have a section public comment on any agenda item, but my school board doesn't offer that at any time during the meeting.
Well, let me ask you this. Do they not offer it after the meeting, or is it just not on the agenda?
It's not on the agenda, and they don't let anybody know that that's a possibility.
Well, the law does not say that they have to tell everyone.
Right. But they just can't deny somebody if they actually, because I think even at the council meeting, they ask you to sign a little sheet before the meeting starts.
Yeah. Yeah, I mean, that makes
the school board.
Yeah,
room for improvement with my school.
I mean, look, it's a it's a terrible way to do business.
Yeah,
but that's how they do it. And
I may just approach them and just remind them that
yeah, but I've never seen it on the agenda.
Yeah, my parish council does that, which is kind of nice.
Yeah, I mean, that is great. But I guess my point is I've never seen public comment on an agenda. Even when it happens, it's not on the agenda.
Right.
They bring up the agenda item, they discuss it, and then they say, is there any public comment on this agenda?
Yeah, they don't ask that question.
Well, they're not following the law, and
right.
Tell them that.
Well, the big thing, and I think a lot of people in the state that goes to meetings will tell you, there's a lot of councils that will not let the people comment unless you went and put your name on the agenda before the meeting, and then they still deny them sometimes because it's controversial.
Well, hang on, guys. I don't want to have a BITCH session about the school boards, and I mean we all know that they have lots of problems, but at the end of the day, if they're not allowing people to comment, that's illegal. They can place reasonable restrictions on when and how long, and that's it. And if they are telling people that they can't comment because they got to the meeting late, I would argue that's illegal as well, but that's not our problem.